Good morning and welcome to the 10th meeting of 2025 in Session 6 of the Equalities, Human Rights and Civil Justice Committee. Maggie Chapman and Evelyn Tweed are both attending remotely today. Our first item of business is consideration of Motion S6M 17314 in the name of Tess White, that the Equalities, Human Rights and Civil Justice Committee recommends that the Parliament remove Maggie Chapman from office as a member of the committee. I refer members to paper 1 and invite Tess White to speak to and to move her motion. Tess White, please.
Thank you, Convener. Convener and members, my motion today under Rule 6.3 of the Standing Orders calls for the Equalities, Human Rights and Civil Justice Committee to recommend that the Parliament remove Maggie Chapman from office as a member of the committee. It follows Maggie Chapman's public comments in Aberdeen on the 20th of April 2025 relating to the Supreme Court judgment in For Women Scotland versus the Scottish Ministers. Maggie Chapman said, and I quote, "And we say not in our name to the bigotry, prejudice and hatred that we see coming from the Supreme Court and from so many other institutions." And she added, "Not in our name, never in our name." Her outburst was shocking and totally unjustified attack on the rule of law. Her comments about the Supreme Court weren't just rabble-rousing, they were dangerous and incendiary. Maggie Chapman has been Deputy Convener of this committee since June 2021. Our remit as a committee includes civil justice. She is not a private individual, she is a legislator. And as Deputy Convener of the Equalities Committee, there is a high bar for conduct. Words matter, tone matters. There must be boundaries around behaviour and rhetoric. Section 1 of the Judiciary and Courts Scotland Act 2008 is clear. Members of the Scottish Parliament must uphold the continued independence of the judiciary. The Faculty of Advocates has written to the committee, not only restating this legal imperative, but highlighting the risk of danger to the members of the Supreme Court created by Maggie Chapman's comments. The faculty was unequivocal in its criticism of Miss Chapman. Its correspondence to the committee said her comments were, and I quote, "beyond the pale," and that her behaviour was irresponsible and reprehensible. It added that her comments failed to respect the rule of law and constitute an egregious breach of Miss Chapman's duties to uphold the continued independence of the judiciary. It's worth noting that the correspondence came from the office bearers of the faculty, and that includes Ruth Crawford KC, Treasurer of the faculty, who acted for the Scottish Government in the case in question. The faculty called on Maggie Chapman to apologise, but no apology has been forthcoming. Instead, Miss Chapman has doubled down on her remarks and refused to reflect on her position. She is devoid of remorse. And in doing so, her position as Deputy Convener and member of this committee is clearly untenable. Let me be clear that the Supreme Court's ruling on the 16th of April was about correctly interpreting the law as it stands. Page 2 of the judgment states as much. The Supreme Court was not making policy, but answering a question about statutory interpretation. As legal academic Scott Wortley at the University of Edinburgh said, judgments can be legitimately subjected to criticism. No one's saying, committee, that you can't disagree with a legal outcome or point to the potential consequences of that outcome. No one's saying that. But in doing so, Scott Wortley adds that any legitimate criticism should be made while respecting the independence of the judiciary and the importance of upholding the law. Maggie Chapman's emotive remarks did not meet that test. The judiciary cannot defend itself publicly, but she used words like prejudice and hatred, which suggests animus on the part of the Supreme Court judges. And in doing so, she attacked the judges' perceived motivations rather than critique the substance of the ruling. That's why her comments are so deeply disturbing, and why Maggie Chapman has failed to discharge her duties as Deputy Convener of the Equality Committee. Words matter, especially when they're weaponised. Rather than take the heat out of the situation, Maggie Chapman doused it in petrol. As a committee dealing with civil justice, we now have a Deputy Convener who has publicly claimed that Scotland's apex court is bigoted and prejudiced. How can anyone working in the civil justice system have confidence in the committee following her remarks? The SNP First Minister has said Maggie Chapman's comments were wrong. The Scottish Labour leader has said, when we get into the place of attacking the judiciary, I think that takes us down a very, very dangerous route. MSPs of all persuasions have a duty to respect the rule of law, no matter what they feel about a particular verdict. Think of the precedent this will set if Maggie Chapman's comments go without challenge or consequence. And finally, Convener and Committee, I urge my fellow MSPs to do the right thing today and back my call to recommend that Maggie Chapman be removed from her position as a member and Deputy Convener of this committee. I move the motion.
Thank you. I now invite any other member who wishes to speak to indicate now, and I will bring you in. I have Maggie Chapman, please.
Thank you, Convener. I want to begin my contribution by expressing my solidarity with trans and non-binary people across Scotland. I have spoken to many over the past weeks and months, and they consistently say the same thing. They feel under attack. They feel that they've been cast as a group, as a threat to others when we know they are not, and they just want to live their lives as who they are, like any of us. I am very grateful to the many people, trans and cis, who have been in touch with me over the last nearly 2 weeks to tell me their stories. It's been devastating to hear about the exclusion and prejudice they or loved ones have faced, and how worried they are for the future. Some have just been in touch to thank me for standing up for them in this cruelest of culture wars. Because that is what's happening. Trans and non-binary people are having their lives weaponised in absolutely dreadful ways. And for the first time in a long time, human rights appear to be going backwards. And we are already seeing implications for women too, with challenges to our bodily autonomy, abortion rights, and our right to exist as we wish, not according to socially imposed views of femininity or beauty. The Good Law Project and others have produced detailed analysis of how the EHRC's interim statement produced on Friday evening, and indeed the Supreme Court ruling, raise questions about compliance with our obligations under international human rights law. But I won't go into that in detail now. I know we'll spend time discussing this in due course. This debate is about what I said in response to the Supreme Court ruling. I have never questioned the court's right to make the ruling that it did, but that does not mean that I must agree with it. I don't, and I am very concerned about the impact it will have and is already having. Trans and non-binary people just want to be able to live their lives like any of us without the fear of prejudice or violence. But now they are concerned about how their lives and rights will be affected. I have and will always stand up and advocate for trans and non-binary people, not just because it is the right thing to do, but because it is also my job to stand up for my constituents. Some of all of our constituents, or all of us have constituents who are trans or non-binary. Others of our constituents have trans or non-binary children, parents, siblings, friends. They deserve representation as who they are. I will not stop being a vocal trans ally. That is what I was doing in Aberdeen nearly 10 days ago, as I had done in Dundee the day before, and as I've done on our streets and in our Parliament many times over the years. Thousands of LGBTQIA+ people and their allies gathered on our streets after the Supreme Court verdict because they were angry, afraid, and uncertain of what lies ahead for them and their loved ones. And we know our courts reflect our society. We've probably all criticised court judgments in the past, when racist or homophobic laws were upheld, when women didn't get justice for the abuse and violence they'd faced, when coal miners were convicted of offences during the miners' strike of the 1980s. Indeed, this very Parliament pardoned all those convicted with the Miners' Strike Pardon Scotland Act just a couple of years ago. That's not to say that the courts did not have the constitutional right to make those judgments. Of course they did. But we would surely all hope that if those rulings were to be made today, they would have been made differently. This ruling did not happen in a vacuum. It happened with a backdrop of a culture war that has seen trans people and their loved ones being targeted and demonised by too many politicians and large parts of the media. But as politicians, we must use our voices to speak out when we see rights being removed or injustices faced by anyone, perhaps especially when minoritised communities are threatened by societal prejudice. We not only have the right of freedom of expression to speak out, I believe we have the obligation to speak out. I do not expect all MSPs on this committee to agree with my views on the ruling or about trans rights more generally, but I hope you will uphold my right to them. This is what was put forward by Lord David Hope, who served as the Lord President of the Court of Session and First Deputy President of the Supreme Court. Lord Hope, not a Scottish Green Party member, said of me, and I quote, "I do not think that she should stand down or be removed from her post, but she should be more careful with her language." End quote. I'll let you be the judge of that. But this really isn't about me. It's about what message our Parliament sends and what we do for people who feel under attack and who are worried about what the future holds. Finally, I'm sorry I'm not with you in person, but I'm at the STUC Annual Congress in Dundee. Congress opened yesterday with a clear statement of welcome to and inclusion of trans people. The General Secretary, Ros Foyer, has expressed her grave concerns about the impacts and effects on trans and non-binary people of the Supreme Court ruling. And trade unionists from across the country spoke passionately in support of trans and non-binary people, expressing solidarity in the face of the onslaught they face. I am proud to be a trade unionist, just as I am proud to be a trans ally. Thank you.
Thank you. I note that Pam Gossel is indicated to come in. Pam Gossel, please.
Thank you, Convener. I would like to thank my colleague Tess White for bringing forward this motion, which recommends that the Parliament remove Maggie Chapman, MSP, from office as a member of this committee. I would like to put on record that I agree with the points that Tess White has made and that I will be voting for this motion. As parliamentarians, it is our duty to set an example for the people of Scotland. After all, our constituents chose us to be their voice and represent their interests in the Scottish Parliament. Unfortunately, the shocking behaviour we witnessed on the 20th April from Maggie Chapman MSP shows that she is not fit for this role. Maggie Chapman MSP and Deputy Convener of the Equalities, Human Rights and Civil Justice Committee said with regards to the UK Supreme Court judgment on the definition of the word woman, "We say not in our name to the bigotry, prejudice and hatred that we see coming from the Supreme Court. This is shocking behaviour that is not appropriate for a member of this Parliament, let alone for the Deputy Convener of this committee, which deals with matters relating to civil justice and to equality. Therefore, her position is untenable." I was privileged enough to witness the UK Supreme Court judgment in the For Women Scotland versus Scottish Ministers case in person in London 2 weeks ago. I was sitting in the courtroom as Lord Hodge eloquently delivered the court's unanimous decision. He used understandable, measured and balanced language, free of legal jargon, which was a sentiment shared by many people I spoke to. our judiciary in this country is tasked with upholding the law and acting as a check on government power. Its role is not to make law, but to rather to uphold it, apply it and interpret it. Under the Judiciary and Courts Scotland Act 2008, members of the Scottish Parliament must uphold the continued independence of the judiciary, and this is something members of this committee, which also covers matters of civil justice, ought to know. For Maggie Chapman to say that bigotry, prejudice and hatred comes from our Supreme Court is not just irresponsible, it is also dangerous. As Roddy Dunlop KC, the Dean of the Faculty of Advocates, has said in the letter on behalf of the faculty office bearers to this committee, that Maggie Chapman's comments constitute an egregious breach of Mrs Chapman's duties to uphold the continued independence of the judiciary and create a risk of danger to the members of the court themselves. The Faculty of Advocates has come out to say that it does not believe that Maggie Chapman's words allow her to properly discharge her responsibilities as Deputy Convener in line with impartiality requirements. Judgments are there to be welcomed and respected, and there is no place for such language. We have seen examples around the world with death threats issued against members of the judiciary. We cannot have such examples repeated here. Scott Waterley, a legal academic from the University of Edinburgh, said that even though judgments are subject to criticism, any legitimate criticism should be made while respecting the independence of the judiciary and the importance of upholding the rule of law. When asked to apologise about making these comments and if she was considering her position on this committee, Maggie Chapman did not apologise but said, "There are plenty of politicians in Scotland prepared to stand up and represent people with transphobic views. People who don't think trans people should be out in public should be allowed to use public facilities like the rest of us do. Labelling supporters of this ruling and all those in favour of single-sex spaces transphobic is reckless and does a great disservice to women and women's rights advocates and is a perfect example of gaslighting. In fact, I have received correspondence from many constituents who express concerns over Maggie Chapman's flare-up. In closing, Convener and committee members, today the public is watching. We all have a duty as members of this committee to decide whether we continue to have people like Maggie Chapman on this committee, tainting the good work we all do here. This cannot be the face of an Equalities Committee. I fully support Tess White's motion and would encourage members to vote in favour of it. Thank you.
Thank you. We'll now move to Paul O'Kane, please.
Thank you very much, Convener, and I'm grateful for the opportunity to contribute to this debate as we consider the motion before us this morning. And this motion has been brought under the standing orders of this Parliament, and I think it is important that we have a full and open debate on it. I do, of course, recognise that debating and deciding upon such a motion is challenging as it relates to a colleague and their responsibilities within this committee. So I wish to address my comments this morning in a respectful tone to all colleagues, dealing in factual information and providing an opportunity for the Deputy Convener to clarify her position to this committee and more widely. And I have not provided commentary on this motion prior to the debate here in committee because I do believe that the proper place to have this debate and to reach a conclusion is in this Parliament. The Supreme Court of the United Kingdom have handed down a judgment in the case of For Women Scotland Limited versus the Scottish Ministers, stating that the meaning of the term sex, man and woman in the Equality Act 2010 refer to biological sex. That judgment was unanimous. And since that judgment, there have understandably been a number of different reactions from different organisations, politicians, academics, lawyers and individuals in society. Many have welcomed the clarity of the judgment and the definitions therein, particularly for women and sex-based rights. Many have expressed concerns about what the judgment will mean in practice for transgender people and their lives. Throughout debates on the broader issues, the discourse has often been heated, and I have consistently said in all of my contributions on these issues that applying general pejorative terms to whole groups of people is wrong and does a disservice to our debates. And I note, once again, Lord Hodge giving the opinion of the court, stated that the court counsel against reading the judgment as a triumph of one or more groups in our society at the expense of another. It is not. Since the judgment, people have exercised their freedom of speech to voice opinions on the judgment, and that is, of course, entirely right in our democracy. MSPs around this committee table and across Parliament have done likewise. But in doing so, it is incumbent upon us all to recognise and respect the jurisdiction of the court, the independence of the judiciary, and the fundamental importance of upholding the rule of law. Indeed, we have a solemn duty as parliamentarians to do so. We have already heard that the Deputy Convener, in her comments in Aberdeen, referred to the bigotry, prejudice and hatred we see coming from the Supreme Court and from many institutions in our society. Whilst I acknowledge the passionate reactions to the judgment as I have previously outlined, I was concerned to read such a statement from the Deputy Convener, which does appear to suggest that the institution of the Supreme Court, and therefore its judges, are engaged in bigotry, prejudice or hatred in relation to their judgments. And I was further concerned by the correspondence received by this committee from the Faculty of Advocates and the response of the Law Society of Scotland, which sought to remind members, and I quote, that the Supreme Court, indeed all judges, are imposed to apply the law. They do not take sides, they decide without fear or favour, consistently with the judicial oath. And quotes again, the Supreme Court's task is to consider the most difficult and complex legal questions, and it must be able to do so without fear or favour. Close quotes. I agree with those statements. And in the past, I have been equally concerned when the Supreme Court was accused by members of Parliament of showing partiality in determining judgments on, for example, the consent of the United Kingdom Parliament in relation to triggering Article 50, or in relation to the legality of the prorogation of the United Kingdom Parliament. This committee has an important role within this Parliament, not only on matters of equalities and human rights, but also on civil justice. And it is in terms of that role of civil justice that I am most interested today. It is our job to scrutinise the administration and delivery of civil justice in the Scottish courts and in relation to the Supreme Court as the final court of appeal. An important example of our role is not only in scrutiny, but also in legislation, given that we have recently considered a bill to amend regulations to legal services in Scotland at stage 1 and 2. That included evidence from the most senior members of the judiciary. For our role to be effective and properly carried out, all members must leave no doubt that we support the rule of law and the independence of the judiciary. To that end, it would be immensely helpful to me if the Deputy Convener would take this opportunity, on record in the committee, to withdraw her remarks relating to the Supreme Court, to state her respect for the rule of law and the independence of the judiciary without qualification, and to acknowledge the concerns raised by the Faculty of Advocates and the Law Society to this committee with regard to her remarks. I appreciate that the Deputy Convener has made a statement already. I do not feel it has done what I have just set out, so I am willing to give way to her, if it is appropriate, Convener, if she wishes to clarify anything at this point.
What I'm going to do is there's a few people who are wishing to come in yet. I will bring them in, and then I can ask Ms Chapman if she wishes to come in at that point, if that is agreeable with the committee. And then Tess White will be summing up at the end.
Thank you, Convener. The Deputy Convener and I have served on this committee together since 2023. There are areas where we agree and there are areas where we disagree. She has a right to express her views on a wide range of policy in relation to her constituents, her region and her party, and I recognise that many people view her as an advocate and a passionate voice for them. But fundamentally, I believe that in order to retain confidence, particularly in terms of this committee's role on civil justice, she must take the opportunity to clarify the points I have raised. In taking that opportunity to do so sufficiently, I believe we can move forward as a committee. Otherwise, I believe we may have no choice but to refer this matter to the consideration of the whole Parliament with a recommendation for removal of the member. Thank you, Convener.
Okay, thank you. I do note that Marie McNair wishes to add a contribution.
Thank you, Convener. I'll be brief in my remarks, and I certainly accept the decision of the Supreme Court. And it is correct that we can agree or disagree with what Maggie Chapman has said or believes. And I think it's been helpful so far. Maggie Chapman has confirmed that she wasn't speaking in her capacity as Deputy Convener of the committee, that she's speaking up on behalf of her constituents. I feel as well, as a member of the committee, that we have no control over what any member of this committee says in their personal capacity. And I think it would be helpful, you know, if Maggie came in further to clarify points raised by my colleague Paul O'Kane. I don't consider this to be a matter for the committee to decide, and I can't support the motion put forward by Tess White this morning, and I will be opposing it, but I will be listening further to further contributions by other members. Thank you.
Okay. Thank you. I'll now bring in Rachel Hamilton as indicated.
Thank you, Convener. I'd like to thank you and the committee for welcoming me to the committee today and giving me the opportunity to speak. I have, as members will be aware, supported my colleague Tess White's motion. Maggie Chapman, who is Deputy Convener of this committee, must be removed. Convener, she has undermined judicial independence and breached parliamentary conduct. I was surprised to hear her contribution just now. Maggie Chapman may not agree with the Supreme Court judgment, but it appears that she has doubled down. She is conflating her own opinion with the interpretation of law. This is not, as Paul O'Kane says, a triumph of one or more groups. This is about Maggie Chapman's beliefs and opinions. We could easily say that women have been victims of a personal culture war, but women have been accused of misogyny, of sexism. They've been accused of racism and bigotry. Therefore, could legitimately make the same claims that we are part of a cruel culture war. That is nothing to do with this. I agree with my colleague Pam Gosell. This is gaslighting, Maggie Chapman. You know, this is a very highly unusual step that the committee is taking today. Calling for an MSP to step down is a serious matter. We've been here before over lesser matters, but never has the Parliament seen such an egregious dereliction of duty. The convener will be aware that I was a member of this committee when Ms Chapman was sanctioned for breaching the MSP Code of Conduct by failing to disclose her formal role as CEO of Edinburgh Rape Crisis Centre while questioning the CEO of Rape Crisis Scotland. That breach, in a way, was small fry compared to what is before us today. I don't have a vote. Other members have a vote. But today we are discussing what Maggie Chapman said in Aberdeen on the 20th of April this year. We've heard today she declared to an assembled group, I quote, "And we say not in our name to bigotry, prejudice and hatred that we see coming from the Supreme Court, and from so many other institutions." We will all be aware that when lawyers take their oath to do the right to all manner of people without fear or favour, affection or ill will, they mean it. Judges make decisions by interpreting the law. And to use the language that Ms Chapman used implies that Lord Hodge and his colleagues were not simply doing their job in interpreting the law, but bringing so-called prejudice, bigotry and hatred to their decision. In response to Ms Chapman's shameful attacks, as we've heard, Roddy Dunlop KC, Dean of the Faculty of Advocates, considered it his duty to speak out in defence of the judiciary. The faculty considers the comments made by Ms Chapman appalling and highlight that the Supreme Court and all judges are in the role to apply the law and not take sides. The most serious of points made by the faculty are that Ms Chapman has failed to uphold the independence of the judiciary. Many people have just talked about that this morning, but also created a risk to the danger to the members of the court themselves. The First Minister, John Swinney, agrees that her comments were wrong and that she was wrong to challenge the independence of the judiciary. So I'm surprised to hear that member Marie McNair is not supporting Tess White's motion. Many will try to defend her comments by referencing the right to freedom of speech. We live in a democracy. But as the legal academic Scott Worley said, that any legitimate criticism should be made while respecting the independence of the judiciary and the importance of upholding the law. So in summary, why should Maggie Chapman stand down? She's not carried out her parliamentary duties in an appropriate manner consistent with the standing of this Parliament. She's brought the Parliament into disrepute. Her comments are a direct attack on the independence of the judiciary. She cannot carry out her duties as Deputy Convener of this committee in line with impartiality requirements in relation to guidance set by the Parliament. And in that vein, witnesses may be reluctant to partake in committee proceedings. I call on all members to put personal loyalties and their personal opinions aside and act to uphold the integrity and impartiality of this committee and vote to support Tess White's motion to remove Maggie Chapman as a member of this committee. Thank you, Convener.
Thank you. Maggie Chapman has indicated that she would like to take the committee's invitation to come in and talk. Thank you, Maggie.
Thanks very much, Convener. I'll just say a couple of words in response to some of the contributions. Firstly, just in response to one of Rachel Hamilton's points, she said I was the CEO of Edinburgh Rape Crisis Centre. That is not true. I was Chief Operating Officer before I was at the point of my election, and at the point of the session, the witness session in question, I had no, that connection had long ceased. So just to correct the record there. Pam Gosal said that we've been chosen by our constituents, and I quote, to be their voice and represent their interests, end quote. That's precisely what I've been doing, representing trans and non-binary constituents and their friends and loved ones who live in the region that I'm privileged to represent. In response to Paul O'Kane and his challenge to me, I say categorically, I do respect the law, the rule of law and the independence of the judiciary. I have no problems in confirming either of those. I've never questioned the Supreme Court's right, constitutional right, to make the judgments that they have made on this on any matter. And I think one of the final thing I would say is just to refrain the words of Lord Hope. And again, I will quote, I do not think that she should stand down or be removed from her post, but she should be more careful with her language. Convener, finally, I just want to say thank you to everybody who's contributed to this debate so far. I know Tess White will be summing up in a moment. I'm grateful for people's thoughts and comments, and I will of course I will reflect and consider what people have said this morning. Thank you.
Thank you. I now invite Tess White to wind up and indicate if she wishes to press or withdraw her motion.
Thank you, Convener. May I give Maggie Chapman one final opportunity to show remorse and apologise for the accusations that she made.
Tess White, if you'd like to sum up and then press or withdraw your motion.
Can I just check? I'd like to ask Maggie Chapman if she's going to apologise just one final time before I move to close.
Convener, if you want me to come in.
Maggie Chapman, are you satisfied that you have said what you needed to say, or do you wish to come in and take the invite from Tess White to speak?
I've said what I wish to say.
Okay, thank you. Continue.
Thank you, Convener. I've heard what the members have said today, and I thank Paul O'Kane for the words and actually stating that we do have a solemn duty to respect the rule of law. If I go back to what Marie McNair, MSP, has said, I do respectfully disagree that we can represent the voice of our constituents, but to do it in this manner and to weaponise language like this and make it a direct attack, I think is a dangerous precedent to say that parliamentarians can act in one way in the committee and in the chamber, but basically the rules don't apply when we're in the constituency and being the voices of our constituents. And I would actually push back and say, is that the SNP position? Because I would ask the SNP to reconsider that, because it's setting a very dangerous precedent. So I go back to, I'd just like to say one point of substance, and then I will go and in summary. There are protections under the 2010 Act for the protected characteristics of gender reassignment. And I think it's very important to say that. In her remarks this morning, Maggie Chapman didn't engage at all with the statutory duties as an MSP. And she didn't engage at all in the premise that as deputy convener of this committee under the 2008 Act, she does have responsibilities, particularly when this committee is overseeing civil justice. What we've seen this morning, convener and committee, is absolutely not a jot of self-awareness. There's no self-reflection at all, which in itself is dangerous. This isn't about freedom of expression. This is about the words that she used to attack the Supreme Court. She's weaponised language and the verdict rather than engaging in the substance of the verdict. No one is questioning her right to critique, but she's violated very important boundaries and disregarded the rule of law. The Supreme Court was clear that trans people are protected under the Equality Act 2010. But today we've seen no apology from Maggie Chapman and no remorse. And therefore, I urge this committee to support my motion that her position on this committee remains untenable. Thank you.
Thank you. I will now put the question to the committee. The question is that motion S6M 17314 in the name of Tess White be agreed. Are we all agreed? No. No, we are not agreed, so there will be a division. Those in favour, please raise your hands. Okay, thank you. Those against the motion, please raise your hands. Evelyn, can we please see you on the screen, raising your hand? Thank you. Okay, thank you. And are there any abstentions? Okay, the result of the division on motion S6M 17314 in the name of Tess White is 3-4, 4 against. Therefore, the motion is not agreed. I am now suspending the meeting for 5 minutes to allow us to bring our witnesses in and commence the rest of today's business.